We now have a history which we can look at clearly because all the memos have been produced that tells us, it seems to me, a number of very interesting things. First, the Department of Justice very early on, essentially after the U memo was leaked, essentially expressed its horror at what was in it. You had a lot of fairly high-level criticism, including by his successors, about how terrible this memo was, about, adult leadership or adult supervision should have been exerted, et cetera, et cetera. This was horrendous. We're very embarrassed by this. Casey and several others, Jack Goldsmith, Daniel Levin, among other distinguished figures, denounced the memo. It was replaced at the end of December 2004 by a memo by Dan Levin. In fact, all of these subsequent memos, whatever the aspersions cast on Professor Yu, came to precisely the same conclusions. In fact, some of the legal legerdemain that Yu used to arrive at his conclusions, and again, not just you, but others in the Justice Department, notably that cruel, inhuman, and degrading treatment could in fact be meted out to prisoners who were under US custody, but who were foreign-born and were being held abroad, was later itself disputed through law by the Congress. The Detainee Treatment Act made it very clear, this is in 2005, that cruel, inhuman, and degrading treatment was in fact illegal and did apply to prisoners being held abroad. Subsequently, within the Department of Justice, Stephen Bradbury wrote a memo that in fact said that none of what you heard amounted to cruel, inhuman, and degrading treatment, which to me, if you look at these documents, completely beggars the imagination. I don't think there's a great argument to be had about torture itself. If you actually look at all the evidence, I agree with the Office of Professional Responsibility that this represents extremely bad and bad faith lawyering, and its conclusions with that regard are absolutely explicit. But to put this on Professor Yu is completely wrong. It's a phenomenon of the American government and the Department of Justice under George W. Bush, and now under President Obama. And that's really, as my time runs out, where we have reached. The fact is that the President of the United States and Eric Holder, the Attorney General, have explicitly said that waterboarding is illegal and that waterboarding is torture. President Obama has said that with regard to these matters, the country has to, and his administration has to, look forward and not backward. There is, however, a certain problem. There are a number of problems. One is that other jurisdictions, including in the UK, off and on in Spain, in Germany, in Poland, in Italy, are looking at these matters, and they are not over. Whether it comes through a case being brought under universal jurisdiction or through some foreign jurisdiction, this will come back to the United States. There's absolutely no doubt about it. The administration, on the other hand, has asserted that it can prohibit torture, and at the same time, through lack of any kind of accountability, has essentially left it an open matter whether or not it's illegal or not. In fact, as I've argued, it's affirmed in essence that if the president does it, in the words of those timeless words of President Nixon, if the president does it, it's not illegal. We are left with this problem, and in front of us an enormous record that I would urge Bolt to put on the curriculum, because again, I'll leave it with Professor Edley, who said this is a very hard case. I agree with him completely, but I think that law schools, and Bolt in particular, if they have a responsibility in this matter at all, and I believe that they do, have a responsibility to consider these matters front and center, to read the documentation involved, including the Office of Professional Responsibility report, and to debate them here, because they have to do with legal ethics and all. Thank you. I will indeed end it there.
panel will now have an opportunity to direct comments and questions to Mark Danner, and I'll begin the process. Harold Koh, Chief Advisor to the U.S. State Department Legal Affairs, has called for President Obama to create an independent commission to investigate torture and human rights abuses committed and authorized by the U.S. government during the last 7 years. So in your opinion, what are the chances that such a commission will be created?
The chances, I thought you were going to say, do I agree with it? And I certainly agree with Harold Koh, who was formerly the dean at Yale and has written very eloquently about torture, among other things. I think the Obama administration, President Obama, missed a very important opportunity not to convene such a commission when he took office. I think, in part, this matter has to do not only with the law, but with public education. The fact is that, depending on how you judge the results of polls, a very substantial number of Americans, and depending on how you ask the question, sometimes a majority, believe that torture is necessary to defend the country. This is no accident. Former Vice President Cheney has been very explicit in saying so. A lot of people have said so. So the political calculus here, it's important to underline, has to be taken into account when we look at the policy that's been followed by this administration. That is, they saw the difficulty politically they would be under when taking any affirmative steps. Closing Guantanamo is one thing, but also trials. And yes, I think a commission would have the great virtue, patterned after the 9/11 Commission, of delving into these things, looking at the question of what information was gained with these things, because information certainly was gained, looking into the decision-making operation, and rendering a verdict on what was done, and in my estimation, why it was a mistake. So that is one, I have a lot of colleagues who say, there's only one choice here. The former president and vice president have to be put in jail and tried. I think that's not only politically inconceivable. I think there are many downsides to doing something like that, and I think a commission is the beginning to seeing justice in this matter. Absolutely.
Okay, good. Thank you. Other members of the panel, make comments, questions? Bob? Jamil?
So, Mark, you made a passing reference to the national press, and I'm just curious to know how you would assess the performance of the national press on this particular issue, on the issue of torture over the last 8 years.
Thank you, Jamil, who is not a journalist. Could I just weep? No, I won't weep. Well, I should be very clear here. I think after Abu Ghraib, post Abu Ghraib, the press's performance, if we're talking about the written press, the Wall Street Journal, New York Times, Washington Post, was for a period pretty good. In part because after Abu Ghraib, there was a flood of leaks from the government, from people who disagreed with this policy. By the way, this is one of the problems with instituting a policy like this. When it's very controversial within the government, and this one was, you can't keep it secret. You have a flood of leaks about it. As I said, Professor Yu's memo of August 2001 was leaked right after Abu Ghraib. It's been public for 6 years. And the press indeed investigated this. In fact, in 2002, the Washington Post, on its front page, 8 years ago, published a piece about stress and duress techniques that was very explicit. So we've had this in the national press for 8 years. On the other hand, the most important part of the press when it goes to public opinion is the televised press, is the broadcast press. And this story has not been deemed televisual, except during a brief period that surrounded Abu Ghraib itself, when those images drove the story. I mean, you had images to cover the words, as it were. So, television covered it for a relatively brief time. It went out of the nation's consciousness as far as television goes and into the written press for a long time, and then emerged again in the spring of 2009.